So again, the utility requirement comes from Section 101, which states that anyone who invents or discovers a new and useful process, and it is that statement useful, that establishes the utility requirement right there. So the first thing I want to talk about is the operable utility component, right? So patented inventions must be operable, and that's part of, but long been held to be part of the basic requirement for patenting. And again, you can get sort of an easy sense of why this might be the case, because we don't want to give patents on things that are not operable, things that don't work, right? So that said, the law is also quite clear that you don't actually have to have a model or a prototype in order to patent, right? So you don't actually have to build your invention in order to patent your invention. And indeed, the law is quite clear that it is presumed that if you're going to file for a patent, that inventions are operable as described, right? So there's a strong presumption, in fact, that if you describe an invention, that it's operable as described. And the PTO can challenge you, but the challenging is only if they have reasonable doubts as to operability, right? So the way that this works is you file a patent application, and it is assumed that whatever you've described works, is operable. If the Patent Office establishes, states, brings evidence forward saying there's reasonable doubts as to the operability, then the applicant has the burden of proving operability in some way, right? And what do we mean by reasonable doubts as to operability? Well, that's a pretty narrow concept in the law, right? One, and the basic idea is that the PTO is supposed to assume that you are properly stating operability unless your invention is based on inherently unbelievable or implausible scientific principles. Inherently unbelievable or implausible scientific principles. And the key case on this is the In Re Courtright case. In Re Courtright deals with a use patent for Bag Balm. Bag Balm is a topical gel lotion that you put on, that's primarily used to rub on cow udders, with the idea that apparently that the material can enhance the amount of milk that's produced or otherwise prevent chafing and things like that. It apparently has been used for many years. You can see from the packaging that it's been around since 1899. In the Courtright case, the patentee claims the use of Bag Balm to prevent male pattern baldness. So the idea here is that you rub the Bag Balm on your head, and it will either prevent your hair from disappearing or will in fact grow new hair. Right? The PTO rejected this claim, rejected it for first for reasonable doubts. They said we doubt this works. The applicant came back, and the PTO said that the reason they are rejecting this for operability reasons is that it was inherently unbelievable or implausible that Bag Balm would be a baldness cure. Right? The 101, the Federal Circuit holds that the Section 101 rejection was improper. It does uphold a written description rejection of Claim 15, right? So here's the issue, right? So what the Federal Circuit says is that it is not indeed inherently implausible that you could cure baldness by rubbing material on your head. And in fact, they cite things like Rogaine, and there are scientifically proven, although how well they work is unclear, but there are at least some scientifically proven substances, the court says, that can indeed prevent, cure, slow baldness, right? And so for that reason, it's not appropriate for the PTO to argue that rubbing Bag Balm on your head is inherently unbelievable. That is simply not true. And so because of that, the court says the 101 rejection is improper, and that indeed the presumption has to be that the patentee is correct in saying that Bag Balm can cure baldness. However, what the patentee was unable to do here was explain anything about how this worked, what the mechanism was, or why this operated in the way that the patentee claimed. And that is a written description problem, right? That is an inadequate disclosure problem, and here specifically a written description, because it's not clear that the invention was actually possessed by the patentee because the patentee couldn't actually describe what was going on. It's a little bit of a dubious rejection of the claim, but you can see what the court's getting at, right? The court's getting at here that the 101 operable utility requirement is one that is a very low bar, right? As long as you are not inherently implausible, unbelievable, then that should not be a bar to getting a patent. Now, however, in many cases, these relatively fantastical type of inventions are going to have significant troubles with disclosure, right? If you can't describe your invention in sufficient details for people to make and use it, then you fail enablement. If you can't describe your invention with sufficient amount of detail to make people understand, make people of skill in the art understand that as of the time that you filed, that you had full possession of the invention, then you're going to fail written description. And I think that's the way that the court is thinking about the operable utility requirement, that really it's mostly a 112 issue. That in most of the time, these patents that don't actually work are going to fail because of lack of disclosure, and that the court doesn't want the PTO to use the operable utility requirement, in part because of sort of the logistics. The PTO doesn't have in some way the ability to do a lot of screening for operable utility. They're not going to make run an experiment on Bag Balm that may take months. They're not going to build labs to do testing, and nor necessarily would we want them to. So I think that the way that the Federal Circuit has thought about operable utility in particular is that it's an extremely low bar. Unless it's clearly implausible, then it's not a bar to getting a patent, although there may be significant other problems with patenting. And again, Courtright did indeed get his patent at the end of the day. So N. Ray Schwartz is a case where the patentee claimed methods for cold fusion, and the PTO rejected this, and it was upheld by the Federal Circuit. All right. Again, the reason is inherently implausible scientific principles, that the cold fusion is inherently implausible. So this gets at sort of a question, which is no matter how low you set this bar for inherently implausible scientific principles, it's still going to trip up some inventions. And the concern is obviously that you don't want to set a bar that is in some sense subjective. Because in part what we want the patent system to do is encourage people to take the big risks, right? To come up with the technologies that really do shatter our understandings of science. That is, in a sense, exactly what we want people to be doing, and we should make sure that the patent system responds to that. On the other hand, we don't want to give out patents for things that are completely ridiculous either, right? So it's an interesting challenge. And cold fusion in Schwartz, it falls on the line, the Federal Circuit says, of being implausible. But one might ask whether that's always going to be the case. There are lots and lots of research dollars being spent right now on various aspects of fusion technology, and with the goal of creating, if not cold fusion, at least a sustainable fusion reaction that's going to be very energy efficient and a variety of other methods. These certainly seem implausible as of 2000, which is when the Schwartz case was, but I think every day they become less implausible. And so one of the things to think about with this is how this changes over time, because the courts have linked this directly to scientific principles, it's important to understand, and I think the courts have done a reasonably good job of this, that over time, what is inherently implausible is going to change, right? But that still means that there's the possibility that tomorrow somebody comes up with cold fusion that actually works, applies for a patent, and because as of right now we don't think that cold fusion works as far as science is concerned, that gets rejected. And yet maybe it actually does work. And again, part of the idea of patent law is to push the boundaries of science, and we want to make sure we set the bar in a way that the people who do take those really big risks are going to be rewarded. And so that's just sort of a general sort of policy discussion, but it is an interesting thing to think about how to set this line and be careful not to screen out too much. And I think that's part of the reason why we saw in the Courtright case that the Federal Circuit was very interested in making sure that the PTO did not set a high bar for operable utility and instead used aspects of 112 in particular to screen for appropriate types of inventions for patenting. So beneficial utility is the second component of utility, and this is sort of fun. This comes from a Justice Story case when he was riding circuit in 1917 in Massachusetts, and he says this is how he described the entire utility requirement here at that time, which is all that the law requires is that the invention should not be frivolous or injurious to the well-being, good policy, or sound morals of society. The word useful, therefore, is incorporated into the act in contradistinction to mischievous or immoral. So the idea here, the sense of the beneficial utility requirement, is that there's some sort of moral or normative character to the utility requirement, and that we are only going to give patents for things that we think are beneficial. Meaning, in that beneficial meaning, not immoral, not mischievous, right? So the question is whether that particular requirement has any real utility anymore. And the Juicy Whip case that I had you read is a great case for that reason, which is it turns out that the slushy machines, and sometimes not even slushy machines, but juice machines at most convenience stores and restaurants, the juice that is shown in the container swirling around deliciously is in fact not the juice that you receive when you press the paddle to get juice. That liquid is actually being stored down below the counter in a container that can be more easily replaced, and in fact the juice that's in the top container is fake and typically includes a bunch of preservatives and color additives and things to make you think it's more delicious than it really is and to maintain it over time and things like that. So basically, and this particular invention was relatively sophisticated because when you press the paddle to get some drink, the level of the liquid in the top chamber would actually drop. So it was, in a sense, a trick. And indeed, the basis of the invention here is that it's really effective at tricking consumers into believing that the juice that they're receiving in their cup is the delicious juice in the glass container and not the juice that's coming up from below in the compressed form. So somehow the defendants in this patent infringement case convinced a district court judge that this was a utility requirement violation based on Justice Story's description of what utility means, which is it can't be immoral. And there was a long line of cases in the aftermath of Justice Story where trickery was found to be immoral and not an appropriate topic for patentability, and therefore patents were denied on trickery. And so the district court judge decided this patent would be invalid because the basis of the patent is to trick consumers into believing that they're receiving a different kind of juice than they actually are. And so the court in Juicy Whip has a long and I think pretty fun discussion about all of the things in the patent law that are allowed, cubic zirconium, for example, that are essentially deceptive, right? And yet we don't really think that those are not patentable. They are, in fact, good inventions. The same with this, right? And that merely being deceptive is not an end of moral, does not mean that you don't meet the utility requirement. And so, is that the end of moral utility? Probably is. For many years, for example, you couldn't get patents on various types of contraception, things like that. That has all changed. The PTO routinely offers patent protection to those sorts of things. And I think that there's a general sense in the law that there really isn't much more to the beneficial utility requirement anymore, that it's really outlived its usefulness. That said, Congress has specifically decided in Section 2181 that there shall be no patents for atomic weapons, that is an area of subject matter that it's simply off limits for patenting, and so that is one example of an area in which there cannot be any more patenting. Other kinds of weapons, by the way, are generally okay. Even things that are illegal are generally okay as far as 101 is concerned. So there's another potential issue that comes up sometimes, which is the chimeric embryos in animals containing human cells, right? This is Stuart Newman applied for this in 1997 for a half human, half animal embryo. He was doing this primarily to make a point about the advancing of genetic technology, and that the public, as sort of to raise public awareness about this. Arguably, this is not sort of a there were arguments, and the PTO did reject this in part on the grounds of beneficial utility. Not clear how strong an argument that actually is, since you can imagine, it sort of, again, depends on your view of the morals. It may be immoral to engage in this sort of research. On the other hand, I think that in many labs all over the world, this kind of research is going on, and that it's generally viewed to be an appropriate line of research. I think that the PTO has trouble with these cases, right? Obviously, the PTO has no interest in sort of being the moral compass for society about what kinds of technology are moral and not moral, and so they would rather stay out of it. On the other hand, these types of patent applications get filed, and they have to do something. And they had a political judgment here that the granting of such a patent, the approval of this, would be inappropriate and would create sort of a public outcry that would make the patent system look bad, and so they decided to deny it. They denied it under beneficial utility grounds. They also denied it on 13th Amendment involuntary servitude grounds, and a variety of other sort of even less salient grounds. Basically made the point that they weren't going to issue these patents almost no matter what. And Newman didn't push it, didn't appeal it to the courts or anything, so it sort of ended there. But these are obviously very difficult cases for the PTO to work through, because they don't want to be in charge of figuring out what is and what is not moral. So how would you deal with this is one question. This is, can I get a patent on a pyramid scheme? Can I get a patent on something that is, illegal, almost certainly immoral in the sense that it can steal money from people, and it's a known scheme that's likely to take money from people as they sign up for the program? Is that moral? Is that not moral? And should we allow patents for it? I think in general, the position of the patent law is that we are going to allow these patents. They may be illegal to operate, but that they are not necessarily violating the utility requirement. There could be some uses for it that are not necessarily illegal. It may be some parts of the world, or maybe some particular context where this would be useful. And so you can imagine wanting to have the ability to have these patents, but not necessarily having a patent, of course, doesn't give you the right to use anything. It just gives you the right to prevent others from using it. And so you may not be able to use these patents even if you can obtain them. Okay, next we're going to talk about practical or substantial utility, which is really where the rubber meets the road, the real heart of the utility requirement in the patent law. The key case here is Brenner versus Manson, which is a Supreme Court case from 1966. The claim here was the process for manufacturing a chemical compound. The issue here was that at the time they filed for the patent application, they did not know of any particular use for this chemical compound. They disclosed in their application that close relatives to the compound, although not the same compound that the process was directed to, were under serious consideration and serious research as tumor inhibiting. So they had this idea that this particular chemical compound might ultimately be quite useful for tumor inhibiting properties. They weren't sure about it yet, but they did want to patent the process for manufacturing the compound. The court holds so that this fails the utility requirement. On the other hand, it's an interesting case because the process actually works to make the compound. So there's a couple layers of complexity here. There's really no dispute here that it operates, right? And so it is an operable utility. Obviously, there's no beneficial utility issue because they say that it's going to create a new chemical compound that could potentially be used in medical research. The issue here is what is now described as practical utility, right? And there's a few possible analytic frameworks that could be used here. What Manson says, the patentee argues, is that as long as the patent is operating for its intended purpose, as long as it's operable, that really is the only requirement. And here this is clearly operable. The patent is for a method of manufacturing, and it clearly works to make the compound in question. There's the story approach, the beneficial utility approach, which this also clearly meets, which is as long as it's not actively harming society in having this invention, then it's patentable, and this clearly meets that. But what Brenner does is sets up a new rule, which we now understand to be sort of the practical utility requirement, is that in order to get a patent, you have to have an identifiable and specific benefit to the patent, to the subject matter of the patent. And here, although they had some conjecture about what precisely this was going to do, the patentee at the time of filing did not know of an identifiable or specific benefit to the patent, and therefore it failed the utility requirement, right? And so the Brenner versus Manson rule stands essentially today, is that in order to get a patent, it must meet what we describe as practical utility. There must be an identifiable, specific benefit, and we now know this as the Brenner rule. So one question that comes up a fair amount in this context is, well, what about an identifiable and specific benefit that goes to the following, which is I make a chemical compound and I identify in my patent application that the identifiable and specific benefit is that if you create 5 pounds of this, it can be used as a doorstop. Why isn't that work to meet the utility requirement? Well, the issue there is not so much the utility requirement as I think it would violate best mode and disclosure purposes, right? So because you were making a disingenuous claim about what you thought the invention was useful for, it was sort of creating sort of a specious use merely to cover the utility requirement. That would be an invalid patent, probably under the best mode requirement. As well as having potential disclosure issues. So that is generally not thought to be a way that you can overcome the practical utility requirement. You need to have an identifiable, specific benefit that's directed strictly to the purpose of the claims as you conceive them. So the big debate in the utility area has been that this is, it sets the bar fairly high. Unlike operable utility, which is an extremely low bar, beneficial or moral utility, which probably doesn't even really exist anymore. The Brenner rule is a real thing, and it does pose real obstacles to real patents on a fairly regular basis. And one issue is it's going to have differential effects across fields, right? There will be fields, there will be areas of technology where we are simply less sure about identifiable and specific benefits to, for example, chemical compounds, or as we're going to see in the case we're going to talk about now, the Fisher case, DNA sequences. And so is it good or bad that it's going to have differential effects? I think that depends on your perspective. It's certainly going to be more of a barrier in chemical fields that are less certain, where we don't know outcomes as well. It's going to have more effect in new areas of biological research where we are less certain about what the results are. On the other hand, you might argue that we don't want to give out patents in those fields precisely because we aren't sure yet, because they're moving relatively quickly, because there's a lot of innovation in those fields. Maybe we want to be more hesitant to give out patents. And the Brenner rule sets an appropriate standard for making it somewhat more difficult, although not a lot more difficult, somewhat more difficult for patentees in these areas. A key thing is when is utility evaluated? It's evaluated at the date of invention, which is usually, unless you've got a priority issue or some sort of swearing behind prior art issue, be the date of filing. Of course, after March 16, 2013, this is all going to be the date of filing. So it's a filing date issue and encourages, in a sense, later filing. Right? Because the longer you wait to file, the more information you're going to have about the utility of the patented invention, and therefore it's much easier for you to overcome the practical utility requirement. The practical utility requirement was updated in the In re Fisher case in 2000. The claims here were to express sequence tags, essentially purified DNA nucleic acid sequences that encode proteins and protein fragments. And this was not for human DNA, this was for corn DNA, maize plant DNA. And the question here is the claims for ESTs coding for certain kinds of maize proteins. And in the utility disclosure, they weren't exactly sure what these proteins were coding for. Well, they knew what they coded for, but they weren't sure what the specific use was. But they disclosed in the document several possible uses that you could use these ESTs to probe for different kinds of mutations or diseases in maize plants. You could detect mutations or diseases. You could monitor reproduction, for example, and make sure it's going well or going as expected by evaluating using these ESTs. So they disclosed a number of possible utilities. Right? The PTO rejects them. It says none of them meet sort of the Brenner versus Manson rule, the Brenner rule of an identifiable and specific utility, is that these were sort of general hopeful statements or in a sense a research plan rather than a specific and clear statement of what these particular ESTs coded for. Right? And the Federal Circuit agreed and said that this was simply not specific enough to meet the rule for practical utility. It's not a specific, these types of sort of generalized disclosures of possible uses, as the court described them, were simply not enough to overcome the practical utility requirement. And so what do applicants need to show? Well, they certainly need to show something quite specific and something, according to the court, that targets these ESTs in particular. And you know, again, the debate is this too high? Is it going to make it too difficult for people to get patents in this particular area? Because the reality of the technology is that we don't have a lot of ideas about exactly what the inventions or these types of inventions might actually do. We know in general what they can be used for, and that's the type of disclosure that Fisher provided. And so it's sort of a general versus specific type of debate. In 2001, the PTO follows up in the Fisher case and establishes what the utility guidelines. And the utility guidelines require two kinds of utility to meet the practical utility requirement: a specific utility, a utility that is specific to the subject matter claimed. Again, this tries to avoid the using 5 pounds of it as a doorstop issue. And then a substantial utility, which they define as being a real world use, right? So going back here, the patents, the Fisher patentee would have had to show under the 2001 guidelines that there was a specific utility directly related to these ESTs, and that utility had a real world impact. All right. And where they really, I think, fell here is that they were not offering in their utility disclosure a specific enough use. That they were offering generalized uses for ESTs generally, but not for these particular ESTs themselves. And therefore, that did not meet the requirement, and it failed the utility requirement. Right. The other thing the court in Fisher holds is that concerns about patents generally shouldn't be considered under Section 101, right? And this obviously has been outpaced by events, and Myriad, which was argued recently, is going to change that a fair amount, and that the ESTs under the Fisher rule are certainly patentable as a matter of subject matter as long as they can show a specific type of utility. Judge Rader has an interesting dissent in the Fisher case where he argues that ESTs are really just research tools. And if you've got a tool for research, then the types of disclosures that you're going to provide are exactly what Fisher provided. And they say, he argues that a microscope would have very similar types of disclosures. What is the actual practical utility of a microscope? Well, you use it, you look through it, and you can look at things, right? That's not particularly specific. There's lots of ways you can look at things, but there's obviously particular advantages to having a microscope as a research tool. In fact, it's indispensable in that sense. And so his argument is that this is, taking Brenner a little too far and making it too difficult for people to get patents in areas of rapidly advancing technology. And that the policy here should say that we are going to allow patenting of these kinds of research tools as long as you specifically spell out what kinds of advantages these tools offer to a researcher, and that's his concern. And so that's a debate, I think, that's still ongoing. Patents on research tools are a controversial area. We touched on them a few times in the semester. Because they raise a number of important issues about if you have a patent on a research tool, do you have too much power to affect sort of the downstream research that's conducted with that research tool? On the other hand, if, as Judge Rader says, we disallow patenting research tools, then it's going to diminish, at least marginally, the incentives for people to develop new and innovative research tools. And that is probably not something we want either. So it's a split policy conundrum there. And frankly, a debate that goes on in the patent law almost every day. So finally, let's talk briefly about the policy of the utility requirement. And the first way to start here is why have a utility requirement at all, right? Why not just say, look, the inventors have very little incentive to file for truly useless inventions. Because it costs money. It takes time, money, resources to file for patents. And if they're useless, then they don't do anyone any good. And frankly, they probably don't do a ton of harm either if you have a useless patent, right? And so one answer to that, I think, is perhaps that there might be an anti-fraud sort of concern, right? That having a patent, even on something that's completely useless, offers in some sense a stamp of approval that many people might think is real about the invention. And you will often, those of you who might watch late night TV, you will often see people who describe their products as patented by the U.S. government, right? Essentially trying to turn a patent into some sort of seal of approval of the utility, the quality, the nature of the product, when in fact that's not the case. I mean, having a patent might say something about whether it's new, useful, non-obvious, but if there's anything you should know by now, and after having taken this course, is that having a patent really doesn't guarantee anything in terms of whether the product works or is in fact all that valuable. It just merely means you met the standards for patentability according to the PTO, right? So that's still, that might be a reason to have a utility requirement, but I think the better reason is that utility is really about timing, right? And what the utility requirement does is it polices the timing of patenting your invention, right? And think about it this way, right? If you have a strong utility requirement, you're going to patent later, right? And if you're going to patent later, then as a society, we're going to be better at allocating the patent rewards, right? Because the people who've actually derived a use for a particular invention are going to be the ones who are more likely to get the patents, right? And because that means they're the ones who actually figured it out, right? And so we're going to allocate the patenting reward somewhat better in those circumstances, right? If you have a weak utility requirement, right, if you don't require much in order to meet the utility requirement, then people will be able to patent earlier. And given, of course, all the other incentives in the patent system, they're going to want to patent earlier, right? They're going to want to patent as early as they can. And that means you're going to get earlier disclosure. You're going to get earlier disclosure of the invention because of the 18-month publication, and the patent's going to be granted earlier, and the patent's going to expire earlier, the earlier you disclose, right? So this is the balance, right? On the one hand, if we patent later, then the inventions that get patented are going to be more perfect, right? They're going to be better thought through, maybe more heavily researched. Maybe the person getting the patent is the person who actually did the most work to figure everything out. And so that would be good. On the other hand, a weak utility requirement helps people get into or encourages even more people to get into the patent office, and has a number of other benefits in terms of the disclosure. Right? Are there other reasons for a weak utility requirement? Well, there's a few. One is you might want to avoid subjective determinations about technological utility, right? If you have a very weak utility requirement, then you don't get the PTO involved in trying to decide what's good technology, what's bad technology, what technology works in a scientific sense, which technology doesn't work in a scientific sense. The PTO is just sort of out of that, or largely out of that, if you have a low bar for utility, right? And another reason is how much harm can useless patents do, right? Is it really worth spending a lot of resource to try and screen for useful patents when almost by definition having a useless patent isn't going to do a lot of harm? Maybe, maybe not. This might, arguably they could clog up the channels of, raise uncertainty in commerce about what things are and aren't covered. There might be some fraud related to useless patents. People may purchase goods that have a patent number on them even though they're useless, things like that. So there might be some level of harm. On the other hand, you might argue that the harm is pretty low, and that any harm is sort of offset by the potential downside of screening out and disallowing patents on inventions that are in fact real inventions, even though they may seem at the time scientifically implausible.